do you have any documentation about the value of the rug before she delivered it to the consignment store?
No, Your Honor.
Furniture brokers reserved the right to no longer do business with her, and that she was no longer welcome on the premises.
I'm sorry, Your Honor.
Are you an attorney for Ms. Harvey?
I am, Your
I'm
Honor.
sorry, for Ms. Weller. Ms. Weller, I looked up.
Oh, Ms. Weller's here with me.
Oh, okay.
Mhm.
Good morning.
Morning.
On behalf of Furniture Brokers of Westlake.
Yes.
Good morning, Your Honor. Joseph Bays.
Mr. Bays, are you counsel?
Yes, I am. And Ashley Harvey is my client, Your Honor.
Okay. All right. Good morning to you both. When I reviewed the petition earlier today, it looks like plaintiff signed a contract for consignment of a rug. Is that correct?
That's correct, Your Honor.
All right. And the rug was sold at substantially less than the plaintiff was anticipating.
That's correct, Your Honor.
All right. How much is the claim for today, Mr. Heinrich?
I'm sorry, Your Honor.
How much specifically is the plaintiff seeking?
$4,000.
All right. Let me go ahead and swear in the parties. I recognize we have counsel, but just in case we end up, you call us witnesses or we have some testimony. If I could have Ms. Weller and then Ms. Harvey, if you'll both please raise your right hand. And do you understand that by appearing in court today and offering testimony, you're swearing to tell the truth, the whole truth, and nothing but the truth?
I do.
Fantastic. All right.
I'll scoot back up a bit. So
All right, then. Mr. Heinrich, why don't you go ahead and give me kind of the bulk of the case? So there's a contract. What
yes,
happened?
Your Honor, the contract provided that the Furniture Brokers of Westlake was to provide an inventory list and an initial pricing list at the time the property was consigned for sale, and that was not furnished to Ms. Weller. And then they proceeded to sell the rug for a price that she would have never agreed to because it was well below what the rug was worth.
All right. And Mr. Vise, would you like to make an opening statement or would you like to wait till the summation of the plaintiff's case?
I would like to make an opening statement, Your Honor, because I think it just kind of provides context.
Yeah.
So this case basically arises from unfortunate circumstances with consignor's remorse. The evidence will show that at all times furniture brokers acted in accordance with the terms of the contract as agreed by the parties. Obviously, it's the terms of the contract that control. On August 24th, 2023, Ms. Weller emails Furniture Brokers of Westlake to inquire about consigning 2 of her rugs. At that time, that store declined the rugs. Ms. Weller then emails Furniture Brokers of Lakeway location to see if they're willing to consign. At that time, the Lakeway store, prior to responding to her, plaintiff decides to travel to the store with the rug, so she did not receive a response. When she arrived at the Lakeway store, the parties entered into the consignor agreement to sell the 2 rugs at the Lakeway store. At that time, Ms. Weller had no written appraisal, and Ms. Weller would have been told that she'd receive an inventory list and initial pricing approximately within 24 to 48 hours. If not received, she would have been told to follow up with Furniture Brokers. The inventory list with initial pricing was to be sent via email. So that's how it would have been received by Ms. Weller. On August 25th or 26th, 2023, an automated email would have been attempted through the consignment software Liberty, which is customary for all items that are contracted with Furniture Brokers. This is not a customer service email. It's not a direct interaction with Furniture Brokers representative. On the contract, as shown as an exhibit, Ms. Weller improperly wrote her email, and it does not include a domain name. Therefore, an email could not have been delivered. And despite emailing with customer service on the 25th, Ms. Weller did not ask about the item list or initial pricing of the rugs. She was a returning customer to the store. She would have had knowledge of Furniture Brokers' pricing process and the terms of the contract. She actually previously entered into several agreements with the store. Furniture Brokers sets its initial pricing of items based on several criteria, including the item's brand, the quality, the condition, the current market value trends, web-based research, past store sales history, and owner input. Pricing is kind of based on their 30 years of experience in the industry. The rugs, like all items, are priced to sell within 1 month per the terms of the contract. A week then would elapse before Ms. Weller decided to contact Furniture Brokers about the listing inventory. And when she did contact them on the September 1st, 2023, which is Labor Day weekend, she discovered the rug was in the custody of a customer for what's known as a try and buy. It's essentially they hold on to the rug for 24 hours to see if they're willing to buy it, if it works for them. At that time, Ms. Weller threatened police action if she did not have her rugs returned. After going back and forth with the representative for Furniture Brokers, Ms. Weller called the Westlake police to Furniture Brokers in the Westlake location. After arriving at the store with the police, she was told by staff members that that was the incorrect store. It was actually a Lakeway store that had the other rug at that time. She then left the Lakeway location and called the Lakeway police to that store. The police arrived prior to Miss Weller showing up, and Miss Harvey spoke with them. When Miss Weller arrived at the store, she was told not to enter. The signed contract at that time was produced, and the second rug was returned to Miss Weller. And then the police also told Miss Weller that furniture brokers reserved the right to no longer do business with her and that she was no longer welcome on the premises. After the police encounter, Miss Weller returned to the Westlake location, despite being told that she was not welcome. At that time, she had one other item consigned, which was a piece of art. As coincidence would have it, a customer had purchased a piece of art that same day and was walking out of the store when she arrived. Upon seeing this, she forcibly took the art from the customer's hands, who had rightfully purchased it. Ms. Harvey spoke with the customer, and ultimately the piece was returned to her. The customer was understanding, but furniture brokers kind of had to retract that sale. The following day, on September 2nd, Ms. Weller returned to the Westlake location and dropped that same piece of art off she had wrongfully taken the day before. After sending an email to my client, it was ultimately decided that furniture brokers did not want the piece. They were not going to accept it because they were no longer doing business with her. So it was ultimately donated. Furniture Brokers, as a store, has had more than 13,000 consigners since its opening 30 years ago. It relies primarily on word of mouth for business. By choosing to show up to both stores with law enforcement, she caused harm to Furniture Brokers' reputation. She interfered with the customers and the sales on Labor Day weekend, which is one of the most profitable of the year for Furniture Brokers. And this is, Furniture Brokers prior to this had no police incidents, never been involved in a lawsuit, nothing like this. I'm confident that the evidence will show, Your Honor, that the contract terms, which control Furniture Brokers, did not commit any breach of the contract, and that no damages were sustained by Ms. Weller because the rug was fairly priced and done so in accordance with the terms of the contract. And I would just like to point out as well, a check for the sale of the rug was issued to Ms. Weller. It was not cash, Your Honor. And thank you.
Let's take a look at the contract. Let's start with that, since I definitely hear that there's a contract that I love it. We got a contract. That's always a positive thing. Let's see. And Mr. Heinrich, do you know if that was provided at the time of the filing?
Your Honor, it's marked Weller Exhibit 2, which was emailed.
Looks fantastic. Let's pull that up. All right, I'm going to share my screen. Let me just double check here. I don't think there's anything on here that looks like personally identifying information. I'm recognizing that we're on YouTube, y'all. I'm not trying to have strangeness happen from that. But all right, here's what we've got. So, Mr. Baez, everyone agree this is a copy of the agreement between the parties related to these rugs?
Yes.
Yes, Your Honor. I would just point out that there was a back to the contract as well. It's not really necessary. It was just it listed the two rugs and what they were, their values, so the 700 and 400.
Mr. Heinrich, is that correct? Is there a back page to the contract?
I'm sorry, Your Honor.
Mr. Baez is indicating that there's a second page to the contract. At the back of the first page had some there were some notes on that.
Your Honor, I'm not aware of the existence of a second page of the contract.
It's okay for today's proceeding, Your Honor. I'm not going to make any reference to it, but I could pull it up. It's essentially that those are other items I sent. Those were previous contracts she had entered into, but the back page just listed the two rugs.
Okay. All right. So let's take a look here. Consignor number, consignor name, address, H.A. Weller 00. And then there's no.
It's HN.
I'm as a plain reading of this, I see what looks to be like H.A. Weller. I don't know. H.N. I mean, right. And then there's
Your Honor, it's H.N. It's
Sure.
H.N.
I can't tell, and any reasonable person looking at it could interpret it other way. Here's what's definitely missing. Where does this go? At Gmail, at Yahoo, at AOL, at whatever, right? That's not a complete email address on its face.
It does not appear on the page, Your Honor, but in fact, my client has received emails using that email address with the correct designation of entity from Furniture Brokers.
Okay, that's just something I heard in an opening statement, so I'm noticing right away that on its face, that's not an email address, right? Here's a phone number, though. Cool. I agree to the stated terms below, consignor signature, and then Ms. Weller, there's a signature here that bears that name. Item condition, Furniture Brokers has high quality furnishing silver pieces. Delivered items that need to prepare cleaner conditions will be rejected. Christmas holiday items accepted. Moving services available. We no longer accept items with a resale value of less than $25. Items are priced based on brand, quality, condition, market value, web research, past sales, stores history, and owner input. Initial prices are set with a desire to sell the items within 1 month. Antiques and collectibles priced based on similar auction sold prices. Inventory list will be emailed after research is completed. The pickup date shows the last date of pickup unsold items. After the pickup date, the item is expired. So prices are set with a desire to sell items. That price is determined by all of these factors, one of which is some owner input. An inventory list with the initial pricing gets emailed after research is completed. So there's no real timeline in that, because after research is completed, and I guess this is the items that we would put into that web-based research. Is that the only one, or is it all of these things? We'll see. If an item doesn't sell within 30 days, there's an automatic discount of 20%. This sold within the 30 days, though, so this clause doesn't come into account. Is that my understanding?
Correct.
Yes, Your Honor.
Okay. Expiration. If it hasn't sold after 30 days, that's not the issue here. This one did sell. It sold very quickly. Owners agree to have their items for a minimum of 30 days before getting them back. So got to allow us to sell it for 30 days before you come and pick it back up. But after that, you've got to come and pick them up. Otherwise, they expire. And then they become, oh, I see. If you don't get it, then it becomes ours. And we won't pay you for things that are in an expired state. I mean, okay. Delivered items too small, damaged, or deemed unsellable are donated. Consigners get 50% of the actual selling price. Checks are sent at a mailing address on the form. Checks are sent around the middle of the month and include payment. Cumulative net of $10 is necessary for us to mail the check. We charge $1 for each check and $25 for reissues that may apply. No responsibility for loss, damage, or destruction, although precautions are taken to prevent it. Keep your items covered by your homeowner policy. So our store burns down, that's not on us. Make sure you have it covered by your homeowner's policy. All right. A little bit of a bailment situation, right? You go and you deliver your items there. And then if I'm kind of reading between the lines here, a little bit of an breach of contract. It's not really a conversion situation because she was authorized. It was there for the purposes of being sold. The question is, was it sold at the correct value? And this just says about value that it's going to be determined by these factors, and that an inventory list is going to get emailed after research is completed. The inventory list is going to include initial pricing. And that initial pricing is set with items for 1 month. There's nothing on here that indicates people can say absolutely not, right? It's one feature of that.
Of course, Your Honor, it's the plaintiff's position that the reason for furnishing the list is to provide people in the plaintiff's position with an opportunity to object to the listing price. They're not agreeing to list it for just whatever price Furniture Brokers determines. They're entitled to review the price before it's actually listed.
Are they? I mean, I understand why you would want that, but as I read this as a plain terms, especially because of this one right here, owners agree to have the item available for 30 days before requested to retrieve them back. And in the determining of price, it says that it's based on all of these factors with owner input, but not that that's the determinative factor or that the owner can say that's not enough.
Well, without the opportunity to object to it, Your Honor, basically the property is held hostage by Furniture Brokers to sell for whatever number they deem to be appropriate based on their research.
What would your research indicate that the rug should have been sold for? What would the price that y'all would have wanted it to go for?
Well, $4,000. Yes, Miss Weller says $4,000.
And what is that based on?
It is based on the appraisal which Mr. Mosen prepared, as that the word is worth between $4,000 and $5,000.
When was the appraisal created?
It was actually created after this lawsuit was filed to try to determine what the value of the rug was.
That's kind of a strange part of it, right? You already sued and said they didn't charge enough, but how did you know that before?
Well, based on the deal is my client acquired the rug about 30 years ago, and she paid $6,000 for it at the time, and then had an additional $6,000 worth of repair work done on the rug shortly after it was purchased.
Okay, let's get some information about the rug then. I'm curious because that's a lot to it, right? So how old is the rug? Regardless of how long someone's held it, when was the rug created? Do we know that?
Mosen, I don't.
Mr. Mosen probably would be the best one to answer that question, Your Honor. He needs to unmute himself.
If you'd like to call a witness, then let's go ahead and do that.
Mr. Mosen?
Yes, I'm here.
Good afternoon or good morning, sir. My name is Judge Holmes. Will you please state your name for me?
Yes, my name is Mohsen Rizai.
All right. And Mr. Rizai, will you please raise your right hand? I'd like to swear you in now. Do you understand that by appearing today in court and offering testimony, you're swearing to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, I do.
All right. Then Mr. Heinrich, I'll let you ask your questions to Mr.
Thank you. Could you state your name, please?
Are you talking with me?
Yes, sir. Could you state your name, please?
Yes, my name is Mohsen Rizai.
Yes, sir. And what is your occupation?
I wash, repair, and sell Persian rugs.
How long have you been employed in that occupation?
I'm here in the United States since 2000 and back in my country since when I finished my high school.
So approximately, since we don't know your age, approximately how long is that?
Approximately like 35 years.
I got you. In the course of your employment, have you become knowledgeable concerning the valuation of antique rugs like the one that forms the subject matter of this lawsuit?
Yes, I only know about the rugs. That's my job.
Thank you. And have you ever seen this rug?
Yes, this rug, I don't remember exactly what year, but Miss Nancy, one time she brought it to me. I washed it for her, and I remember that rug. It was an old Persian mahal, and I washed that rug one time. I don't remember the exact date, but I did clean it.
Mr. Mosen, do you know the approximate age of the rug?
I can tell it's over 70, 80 years old rug.
I've already emailed you a copy of Weller Exhibit Number 1. Is Weller Exhibit Number 1 a photograph of the rug?
I'm sorry. Can you say it again?
Yes, sir. Is Weller Exhibit Number 1 a photograph of the rug?
Yes. That is the rug. Yeah, that's on the picture.
In your opinion, what is the value of the rug?
I believe that like a minimum, it's I said between four to 5,000, 4 to 5.
Did you prepare a written appraisal for Ms. Weller?
Yes.
And is Weller Exhibit Number 4 a true and correct copy of the appraisal?
Yes.
Okay. Your Honor, I'd offer Exhibit 1 and Exhibit 4 into evidence.
I'm going to share my screen.
I'm sorry. Say again.
I'm looking at the exhibit, sir. Mr. Bies, as counsel for the defendant, any objection to this being an accurate depiction or a picture of the rug in issue?
I'm just going to object.
Yes,
I have no idea what photo is from.
Mr.
I can't
Heinrich,
say.
what is this photo from? When was it taken?
About 2018, we sold our house in Seabrook and moved to the Austin area. And this picture was made before that for the realtor purposes and for us to preserve the legacy of our home. So this is one of the pictures.
Okay, so this photo was taken in 2018?
Yes,
So about 5 years before the rug was sold?
that's correct.
Ms. Harvey, any thoughts? Do you know what the rug looked like? Is this a similar depiction of the rug?
Yes, this is the rug that she emailed to the store for pre-approval. And I thought she had pointed out that this was a picture that was taken like 20 years ago when she initially started consigning in 2021 in Westlake.
Okay. What I'm hearing, for whatever limited evidentiary value there is, this is a depiction of the rug. Rug is pretty large. It's room size. What are the dimensions of the rug? Mr. Heinrich, do you know?
Is it an 11 by 14?
11 by
It's
15.
11 by 15. Mhm.
Okay. That's exhibit 1. We'll admit it. Exhibit 4 is a copy of from Mosen Rugs and Repairs. It's dated October 2nd of 2023. And so this would have been after the sale, correct?
That's correct, Your Honor.
Okay. Now, how did the plaintiff get the rug back?
No, Your Honor, the rug was not recovered.
How was he able to create an appraisal of something he hadn't seen?
Oh, Your Honor, I think he testified that he had seen the rug and
Yeah,
had
but Mr. Heinrich, I'm asking an obvious question. I can't give you an appraisal of a car that I saw 5 years ago. And he said he doesn't even recall when he cleaned the rug. His testimony just now is, I washed it. I don't recall the date of when I cleaned it. I know it was an old Persian rug that was 70 to 80 years old. And then he created this after you were ready to come to court, but he did not actually inspect to create this appraisal.
He was furnished with a photograph of the rug, Your Honor.
That photo is 6 years old. Do you see my point? I can show you a photo of me in college. You can tell me how my health looks. That's not the same thing. If I show you a photo of my home when I purchased it new a decade ago, it does not look the same way. So I would accept this, but I will, without any objection, be able to say that there's a limited value of this appraisal for me because it's not based on anything but an old photo and his memory. And he doesn't even remember when he cleaned the rug. Do you have any documentation about the value of the rug before she delivered it to the consignment store?
No, Your Honor. No
Just her
other
opinion.
information.
And do you have any research that indicates a rug, regardless of that a 70-year-old rug, size 11 by 15, is worth $4,000 in perfect condition? Any
Ms.
evidence?
Ms. Weller has done some research, Your Honor.
Has that been submitted to the court to review?
It has not been reduced to writing, Your Honor. She can describe the research that she did.
You wish to call her? I mean, first of all, we're still on Mr. Rezai. So do you have any other questions for your witness, Mr. Heinrich?
No, Your Honor.
Mr. Bice, do you have any questions for this witness?
I have a few questions, Your Honor.
And Mr. Rezai, real quick, Mr. Rezai, you got to unmute yourself again, sir. Mosin, you'll have to unmute yourself by pressing *6.
Yes, I'm here, ma'am.
Okay, we're going to ask you, the defense counsel, Mr. Bice, is going to ask you a few questions now, sir.
Yes.
We can't do that.
So, Mr. Munson, is it typical in your industry to perform an appraisal without having the object physically in hand?
You know, the Persian rugs, if I see one time, like 5 years ago, 10 years ago, I physically, I can tell what kind of rug was that. And the price I appraised, it was, honestly, it was my minimum price. If it was a good condition, I can appraise that one like a 15, 20,000. But I asked Miss Nancy, is that I see the picture and I remember the rug and I said it was the same conditions and said I put the minimum price. Minimum is like, and I didn't know that what's going on with her rug. And I just appraised that rug, it's worth 4,000 or 5,000.
My question was, it's just a yes or no question. Is it typical in your industry to perform an appraisal without having the object physically in hand? It's just yes or no.
I don't know what you mean. Can you ask clear what do you mean?
How many appraisals do you typically perform?
No, if I don't see the rug, if I see the rug before, yes, I appraise. But I never see the rug, I don't appraise.
But you don't recall when you saw this rug, correct?
I saw this rug maybe 8-10 years ago. I didn't see recently.
But you will. Do you acknowledge that a rug or any object can change substantially between 8 and 10 years?
She said it was almost same. I didn't expect like a big change with the old rug.
Do you typically rely on a customer when forming your basis of an appraisal?
I'm sorry. Can you say again what that means?
So she told you the condition of the rug, and then you formed your basis for the appraisal. She told you the condition, and that's what you relied upon to form your appraisal.
Yes, because I remember that rug. I saw that rug before. The old rug, you know, even a little bit damaged, a little bit something, but it's not a big deal with the old rug, over 70, 80 years old rug. It's not a big deal if it's a little bit, the worn or a little bit damaged. It's not a big deal.
Do you know what condition the rug was in on October 2nd, 2023?
No.
Okay. And it could have been 10, you said approximately 10 years ago when you might have last seen this rug?
Say again, sorry, say again.
It could have approximately been 10 years ago when you last saw this rug, correct?
Yeah, I saw it that time, yes.
All right, no further questions, Your Honor. Thank you.
Can you redirect, Mr. Heinrich?
No, Your Honor.
All right, Mr. Razai, thank you for your testimony. I don't know that, does either party think they would be recalling him as a witness?
I don't believe that he will need to be recalled, Your Honor.
Mr. Bays, any chance you're going to want to ask questions again of the appraiser?
No, it's okay, Your Honor. I think we're done here.
All right, Mr. Razai, you're welcome to remain with the proceedings. You're also welcome to leave. Thank you for your time so far. All right,
Thank
Mr.
you.
Heinrich, who would you like to call as your next witness?
Nancy Weller.
All right. Good morning, Ms. Weller. Remember that we've already sworn you in, so you're under oath.
Good morning, Judge Holmes.
Would you state your name, please?
Nancy Weller.
Are you the plaintiff in this lawsuit?
Yes, I am.
Were you the owner of an approximately 11-foot by 15-foot antique Mahal rug, which forms the subject matter of this lawsuit?
Yes, I was.
When did you purchase the rug?
We remodeled our home in 94, 95 time frame, and I bought it soon after that. It's sat in my dining room for the next couple of decades, and then we moved to Austin in 2018, 2015. We bought the house. 2018, we moved here permanently. The rug was in my dining room, very infrequently traversed, and it maintained its appearance just as in the picture.
How much did you pay for the rug?
$6,000.
Did you have any repair work or cleaning work done to the rug after you purchased it?
Yes, I did. I paid $6,000 for it to be not repaired, but the back of it was enhanced by a man named Nuri and Sons of Houston. And I actually spoke with his brother. The original Nuri died. I spoke with his brother in California recently. And so it was repaired for another $6,000 and purchased for $6,000 as well.
Now, Ms. Weller, you've already seen a photograph that has been marked Plaintiff's Exhibit 1. And is that a correct depiction of the rug at the time it was located in your house?
Yes, it is.
Okay. Did you consign the rug with Furniture Brokers of Westlake?
Yes.
The document that's been marked Plaintiff's Exhibit 2, is it the document that you recognize?
Yes,
Is this a truly correct copy of the consignment agreement?
yes, although the date received and date priced is scratched out. And on the day I went to get back the Bessarabian rug, someone in the shop, maybe Ashley Harvey, wrote the email was sent on the 25th. It was not. I never received it. Although there were other emails that I did receive on the 25th from the store attendant named Donna. So I received a series of emails, but nothing showing the price of the listed price of the rug to begin with.
Your Honor, I'd offer Plaintiff's Exhibit 2 into evidence.
I think we already admitted that earlier. But any objection to a copy of the contract, Mr. Vise, being submitted?
No, Your Honor. Thank you.
Thank you.
So admitted.
Does the consignment agreement provide that furniture brokers will email you a list and the initial pricing on the?
Yes, it does.
Did you receive such an email from furniture brokers?
No, I did not.
Now, I'm going to show you another document that's been marked. Plaintiff's Exhibit 3. Can you identify this document for me?
Yes, this is a copy of a series of emails that were exchanged between me and the store attendant in Lakeway, first name Donna.
And does this email chain contain all of the emails that you received during the time that this problem arose on August the 24th, say through the 26th?
Yes, there was one other email that I sent, but it was not pertaining to the sale of this rug.
Your Honor, I'd offer Plaintiff's Exhibit 3 into evidence.
Any objection so far, Mr. Bays? I'm kind of reading through these here. I see that-
No, Your Honor.
No
I
objection.
would just like to point out just that the first email in the chain was not included, and that was included as Defendant's Exhibit 2, I believe.
So the first email in the chain is not part of this 6 pages.
That's correct, Your Honor.
There's another email that goes with it.
Yeah, so the first email is, I included it as Defendant's Exhibit 2, and that's just that this is what she initially sent to the Lakeway location on the 24th.
So that's why when she
and
says,
prior to
hi,
this-
Nancy, thank you for the photos. The Donna is responding to this email from Nancy saying, hey, Randy, here are 2 pics of the mahal in my dining room in Seabrook.
And that's the one that was sent prior to her going to the store, yeah.
Mr. Heinrich, any objections to this being a complete copy then? So with this email and these chain of emails, this encompasses the entire set of communications between the parties prior to the rugs being dropped off?
No objection, Your Honor. I think that's correct.
Let me just read these real quick. So, hey,
This-
from Nancy at Gmail to Randy, here's pictures of my rug. And then defendant responds, thank you for the photos. He's on vacation. Are you wanting to consign these pieces? If so, how many? We have a wait list on large items. Perhaps you mean the rug, we're overwhelmed with them. We would need to put you on a wait list. Yes, I want to consign the rugs. I bought them 30 years ago as old rugs. Please add me to the wait list. I don't live near Lakeway. Randy didn't mention a wait list. I can't handle the rugs, which are heavy on my own. I can't pick them up without help. So put me on the wait list. I didn't realize they were already in the shop. So what takes place here? I don't understand. This is 224. Put me on a wait list. And then literally within 20 minutes, I didn't realize we already had them in the shop. When did the rugs get delivered to the store?
On the 24th.
So, Your Honor,
So
Donna was not,
I-
no,
I-
sorry.
This email to Randy, is Randy at Lakeway or Westlake?
Lakeway.
And so well, you took your rugs and dropped them off on the 24th at the Lakeway store.
That's correct.
Okay. Did you get a contract when you dropped them off?
Yes, I did. With no evaluation
I-
of the price of the rugs attached to it.
I got that. I'm
Got
just,
it.
is this contract right here the one that you received when you dropped the rugs off in Lakeway on the 24th?
Yes, it is.
Okay. And then you emailed about it and received a response from Donna at the Westlake location.
I don't know where Donna was. I think she was at Lakeway.
Mr. Vise, do you know?
So I will say Donna's, obviously Donna's not Randy, and she's a little bit older employee there. I don't think she was caught up on what,
I'm just asking, does
communication
Donna work at
with-
Lakeway or Westlake?
Lakeway.
Ms.
Lakeway.
Harvey, Donna works at the Lakeway location?
Yes, this email correspondence
Okay.
went through the Lakeway store.
Got it. So she dropped off her rugs. She sends photos of the rugs after the fact. Donna says, hey, we're going to waitlist that stuff. And then she realizes, oh, wait, we've already got your rugs.
May I add something?
We'll get to it.
Okay.
I mean, what is it, Ms. Harvey?
So the initial correspondence, she reached out on August 24th because our policy is we pre-approve all items. She reached out to, must have called the store, spoke to Randy. Randy said to start the consignment process, send an email with photos. She sent an email with photos, never got a reply because we were very busy. There's only one person at the store.
Lakeway
And-
accepted possession of her 2 rugs.
She showed up with them, correct?
You don't have to, Ms. Harvey.
And we
Ms.
accepted
Harvey,
the rugs. Mhm.
That's what I'm getting at. Lakeway had possession. She dropped off 2 items and Lakeway kept them. It wasn't
I
like
was
she
just
came in the
trying to
middle of the night and left them on the front step.
I was just trying to explain that the correspondence from Donna, went in the next day and noticed
Yeah,
there
I
wasn't a
understand Donna's
reply
confused. That's
to
fine.
Nance's
I'm just,
email, so she
for me
replied.
to understand the chain here, the rugs were already there. That's why I'm confused, right?
Correct, yeah, it is
In
confusing.
the plaintiff's email, hey, these are 2 pics. That doesn't indicate pictures of the rugs I dropped off earlier. It just says here's pictures.
Mhm.
And then there's this whole email chain. And then suddenly, oh, wait, we've got the rugs. That's why I was confused. I got it. Donna didn't realize she discovers it. The rugs are in the Lakeway store. Cool.
Correct.
Fantastic. And then no worries. They have to be rolled up until we have space to lay them out. So there's no discussion here whatsoever between either party so far about value of the rugs, about an inventory, about anything. Just, we got a lot of rugs. It's going to take a while before we put them out. I understand. Thanks for your flexibility. They are great rugs, antique rugs, which should be of interest to someone. So again, we're already at 6:30 in the evening, second day. No one's talking about inventory or pricing. Just cool. Rugs are there. We're not going to sell them yet because we have a big backlog of rugs. And that's the end of this communication chain. Right? Okay.
Yes.
This is the 25th. At 6:30 p.m. on the 25th, there's no inventory or discussion about price. Instead, the impression that I get from reading these is that Lakeway isn't going to try to sell them yet because they've got too many rugs and they're going to put them in the back. All right. What day? Well, so you go ahead and continue with asking questions of your witness, but that just gives me a sense. So now I've got the email chain. Those were admitted. I understand what's taking place. Rugs got dropped off. Randy isn't there. Donna takes over. She says we're going to wait a while to sell the rugs because we got a big backlog of them. Mr. Heinrich, would you like to ask any more questions of your witness?
Yes, Your Honor, I do.
Go ahead.
Did furniture brokers sell the antique Mahal rug? Nancy?
Oh, yes, they did.
How much did they advise you that it had been sold for?
$700
When did you learn that they had sold the rug?
on 8/25.
And how did you learn about it?
I had received a voicemail on my phone from Donna at closing time. And the next day, because the store closes at 4 o'clock, the next day I called back immediately and I was told that the rugs had been sold.
When you talked to Donna,
What's the time of the voicemail you got from Donna?
Best recollection is right around 4 o'clock.
Do you still have the voicemail?
Sorry?
Do you still have the voicemail?
No, I do not. No, sorry.
That contradicts what I'm reading here in the record and the evidence that I was just submitted. Right? Because from you to them at 6:30, you're right. Cool. I understand. Someone should want them. But what you're saying is that you actually got a voicemail 2.5 hours earlier that told you it had been sold.
No, I'm talking about the following morning on August 26th.
What day was the voicemail? Be very clear. You don't have it anymore, so you don't know.
The voicemail was on August 25th.
And that's why I'm confused. You got a voicemail at 4 o'clock on the 25th, but you wrote an email the same day, 2.5 hours later, talking about you can't wait for someone to buy the rugs.
I did not get that voicemail until later after the shop had closed at 4 o'clock. I didn't answer the email until the following day, and I called very early on the following day when the shop opened at 11, and I was responding to Donna's call from August 25th. I inquired why she called, and she told me that they had, and I asked about the pricing of the rugs since I'd never received an email or any other indication of what the attempt was to sell the rugs for. And they told me $700. And I said that the price was outrageously low, that these were beautiful antique rugs. And Donna replied to me, well, I thought I sent the item list price yesterday, which she didn't clearly, because you can see the chain of emails that occurred between Donna and me.
I have lots of questions, Mr. Bies, about how they didn't realize they had a rug. She said, we're going to have to wait a while to sell the rug. And like magic, the rug sold within an hour or so. Like, right?
My understanding,
Would have
Ronnie,
been very helpful to have here today. Someone who actually works there who wrote these emails. Does she still work for the company?
She just retired after 20 years with furniture brokers.
No reason she can't have come as a witness. I'm just saying, she has the best information about it, right? But like the emails y'all just saw that got admitted. Claire, I'm going to share my screen so we can all see this timeline. Because is it accurate that the rug sold the 25th?
No, it is
What day
not.
did the rug
no,
sell,
Your
Ms.
Honor.
Harvey?
Sold on
They-
September
oh.
2nd.
So is the plaintiff, Miss Weller, lying when she says she got a voicemail from Donna that says we sold the rug today for $700?
I can't speak to that. I don't know what phone interaction they had, but to my knowledge, no, that was not
Your records indicate the rug was sold September 2nd.
correct.
Do we have a receipt for the sale of the rug?
We do. It was taken on a try and buy on September 1st and for a 24-hour try and buy, and it sold on September 2nd for $700. And we have that time stamped through our software system, point of sale.
So, Mr. Bays, do y'all have that receipt and the sale information from September 1st and 2nd?
I'm looking for, let's see.
I can,
Actually, was that sent over in the exhibit
I
4,
don't
exhibit
think
5, and 6?
let's see. Well, it was on her check stub. It had the sale date as well. Does she have the original check that wasn't cashed?
I don't need to check. You should have a receipt when you sold it to the person who bought the rug and took it home on a try and buy. If you're telling me that you let a rug walk out of the store on a try and buy and you don't have a receipt of that,
No,
I have lots of questions. So
Of
that
course.
document is absolutely necessary for me to see right now.
Okay, I can provide it if
Your
you can.
consignment store. If you're letting stuff go on a try and buy and you don't know who took it and when, I have lots of questions, especially when there's a huge dispute about the value of something like this. An 11 by
Absolutely.
15 rug is not small.
Correct. I can provide the receipt for September 2nd that it sold for $700. I can provide it in just a couple minutes.
Fantastic. My clerk put in the email box here, our chat box, the email you can send it to.
Okay.
Because that's a question of fact, right? What I'm hearing is that the contract is a little bit vague about whether the seller has any right to refuse the price. And the email chain indicates that the rug isn't going to be sold for a while because you got a backlog of them, which would,
Well,
would lead
I
you to
did-
believe that there's some reason for a delay in an inventory coming. Well,
Da-
we're not
Donna's-
getting to it yet.
The communication about the rug, it wasn't saying that it wasn't going to be sold. We don't display rugs on the showroom until we have an open space. Items are priced and tagged within 24 hours of delivery. So that's why we communicate to consigners when they drop off their items that they'll receive an email within 24 to 8 hours to
Right.
check the pricing and to let us know if they have any questions or concerns or if they didn't receive the email.
And so here would be my questions that I've got for the defendant, some things that would help me understand what took place here, because this is about a breach of contract case. So do you have the email that was automatically generated and sent to the plaintiff with the value of the rug?
It is sent through our software system.
I get how it's created. I'm saying, do you have a copy of it though? Do you have proof that you sent it, even if she didn't receive it? Do you have one that says, here's where it went out?
I don't have one that says when it went out. I have the item
you-
list that was sent.
How do y'all know it got sent then? If you're paying for the software and you're not individually doing it,
We're-
this begs into
Yeah.
question. It is an essential element of what y'all said you were going to do. And this is the part of her breach, is that she never got it.
Well-
Whether she
well,
got it or
you're-
not, if you can prove you sent it, you look a lot better to me. Can you prove you sent it?
Well, Your Honor, even if we would have sent it, it wouldn't have mattered because there wasn't a valid email. There's no domain name.
I disagree
And-
entirely with that contention. I just saw an email chain between Donna and her.
That's customer service, Your Honor. So there is difference between customer service.
This is not a giant
and-
corporation. How many employees are there at the Lakeway store?
4.
Even less exciting. I have 21 employees and I can tell you right now who sent what and when. You're dealing with thousands of dollars of people's goods. She discovered she had the rugs within 2 hours of that email. All you got to do is show me that y'all know you mailed her an inventory and you're looking better. But that's not what I'm hearing. I'm hearing that, well,
We sent an item list within 24 hours to the email that was
believe you did, but
provided
you don't have
by
proof of that.
Nancy. We have over 13,000 consigners. We send over 30 emails a day with deliveries that arrive. We don't go in
Whatever
and check
service you're
and
using has a record
verify.
of it somehow. So what is it? You don't have proof that you sent it. All right. No proof that it was sent, but you do have the itemization that you believe was sent to her. Is that correct?
Correct.
And Mr. Bays, was that submitted to the court?
Let me see. Would that have been the back page of the contract, Ashley?
I'm sorry, what was the
No,
question?
what was submitted with your court in Exhibit 1, Your Honor, is the listing of all the rug pricing for that Lakeway store, which is used to determine a price. And it was produced. I was going to use that for a direct examination of Ashley, Your Honor.
I am more interested in seeing what was actually created about this particular set of rugs. Because the contract says it's going to be created. So either it was or it wasn't. If it was, let me see it.
Ashley,
Yes.
a meeting chat wasn't included, there's a link in there. If you can get that information and send it to the court, they're asking for an inventory that was created for the rug.
Okay, I'm right now I'm getting the stamp of when the rug sold as well as is that. So it's going to take me a minute.
Well, let's take a 15-minute recess. Y'all look through and look for those things, right? The itemization that was created, the actual receipt for the rug being sent out on the 1st and then finally sold on the 2nd. If that's just one document, if you have both, whatever you've got about when the rug was sold, how you know it was sold and what it was sold for. Another question I would have is, when was that price information communicated to the plaintiff? Because the plaintiff is alleging that she learned about it through a voicemail from Donna and that she got that voicemail on her phone. Now, she doesn't have the voicemail anymore, so she can't really prove it. She's testifying to it, but I'm taking everyone at their word because that's what we do here, which is why historical records are always better to back that up because people's memory changes. I can't remember what I had for dinner last night, right? So take a look. We'll take a 15-minute recess. We'll be back at 5 to the hour. We read over the original agreement between the parties, and I'll just kind of for both parties' sake, I'll highlight some things that I noticed about it. Just observations, looking at the agreement of things that are present, things that are not, right? Sure, we're back. So, Mr. Heinrich, can you hear me all right?
I can hear you, Your Honor.
Right. And Mr. Bays, I'm afraid is it Bays? Am I pronouncing your last name correctly?
It's Bays.
Just making sure. I write it down at first and then it gets lost in my list of notes, right? And so I'm glad y'all have it, but then I'm always a little concerned. All right. Just
I'll get by it. So
all right. All right. Well, let me share my screen. So this was one of the exhibits that we've already what just happened here? All my documents went away from me. Sorry, y'all. There we go. Let me share my screen. I'll just kind of, again, share some observations as I looked at the agreement between the parties over the break. So this is the broker's consignment agreement. And this one, when I look at it at the top, I see that there's information about the consignor, but as she signs it, but there's no information from the consignment shop, right? No, I don't know who took this in. There's just at the top, who are you? And what's your contact info? What date is it received? And there's 2 initials here. I don't know whose initials those are. And there's a date on it. And then there's no list on the page 1. Nothing about this indicates what was dropped off. Right. So I don't know. It doesn't on its face indicate that to me. The agreement says that inventory will be sent right here under pricing. An inventory list will be sent after research is complete. And in looking at it, that seems to be the only timeline provided. So it doesn't say it will be done within 24 hours or within 7 days, simply that we'll send an inventory once research is complete. And the research and based upon this, a pickup date is going to be included. So that implies that there's this pickup date, and that's important because if you don't pick up your item within 30 days of the pickup date, it becomes property of the consignment store. So this is the catch date by which we would know who becomes the owner at that point, because until then, the items remain owned by the consignor. And that's why they say keep it in on your home insurance, right? Because it's your stuff until we get 30 days past that pickup date. So in order for a consignor to know what that drop down date is, they would need the inventory. There's no information in here in these clauses about can the consignor change their mind. What there does say is that items must be given for 30 days. Right? So owners agree, and it's bolded, owners agree to show their items for 30 days before getting them back. So is that 30 days from the date they turn them in? 30 days from the day they get the inventory list that has that drop-off date? There's no clearness to that one. So I could think you could make a reasonable argument either way. What does say, though, is that after that first 30 days, because items are priced for them to be sold quickly, that after that, the item will be sold and discounted up to 3 times, going 20% each successive area. So after 30 days, if it doesn't sell, item price is going to go down by 20%. If 30 days it doesn't sell, it can be discounted 20%. 30 more days, it's a final third discount. And if it doesn't sell, then you got the pickup date happening here. That's kind of how I read that to be. But what that implies then is that because the owner has to leave it for 30 days, the owner has the right to change their mind before the first discount kicks in. So I bring my item. You tell me what your research tells you it's worth. I agree to let it sit there for 30 days. If it doesn't sell, I have the right to come and get my stuff before you discount it. If I let you go on the discounted price and it goes the 3 discounts without it being sold, then I have 30 days to come and pick it up. And that's after this pickup date. So I don't know what the pickup date is. I don't know if it incorporates these 3 discounts. That's not clear either. But it does seem to imply to me, at least this way, that after the 30 days, the owner can change their mind. And then there's, again, no information in here about the value of what was sold, of what was dropped off, because there's no list here at all on this page of the agreement, or what the price is, the value is going to be. So just observations when I read this document again, that I see from it, questions that still exist as you look at it. You know, what was each party's impression about what they had signed or what that agreement indicated to them? All right. Now, when we left, I'd had some questions. I was interested in knowing that it appears that on August 24th, the plaintiff did take 2 rugs to a Lakeway location and she dropped those rugs off. And then she followed up with emails the following day to the Lakeway store about the rugs. And there was some confusion with the person she was emailing. That was Donna. So it looks like she may have dropped the rugs off with a Randy. Randy was not there that day. Donna responded to the emails. There was a bit of confusion about the rugs, but eventually they realized, no, we have the rugs. And per the final email, the rugs were not yet on display because there was not room in the showroom for that. There were quite a few rugs. And so in order to display them, you're going to have to unroll them and show them out there. And so that final email, which was the last email from the defendant's office, Furniture Brokers in Lakeway, was at 2:41 saying, sorry for confusion. I didn't realize they were already in the shop. No worries, except they will be rolled up until we have space to lay them out. I apologize for the confusion. And then later that evening, after business is closed, there's an email at 6:30 from the plaintiff to the furniture store that says, I understand. Thanks for your flexibility. Much appreciated. They are great rugs, antique rugs, which should be of interest to someone. And the plaintiff testified that the following morning, on the morning of August 26th, she realized she had a voicemail from the day before at approximately 4 p.m. from the Lakeway store saying that the rug had been sold.
Your Honor, if I can correct that just a little bit, she
Yes.
received a voicemail requesting a call. The voicemail did not say that the rug had been sold. She discovered the rug had been sold when she returned the call the next day when the store opened.
And the voicemail did not state what price it was going to be sold for.
Okay, so you got a call on the 25th and you heard that message the morning of the 26th that said, please contact the store. And did you call the store on the 26th?
Yes, ma'am. I did.
Do you remember who you spoke to that day?
Donna.
And did Donna inform you that the rug was for sale or had been sold?
She said it was sold. The rug is sold.
Did she tell you how much the rug had been sold for?
I asked her and she said $700.
And did you then speak to anyone else at the store? What did you do after you learned the price had been sold?
I asked Donna if she would reach the person who had bought the rug. Donna told me it was on approval. And she said she would. She hung up the phone. She called me back shortly thereafter. She said that this lady lived far away and that she was keeping the rug and would not return it, as I had asked Donna for her to do, and repeated that the rug is sold. Then I spoke with Miss Harvey. I asked to speak to Miss Harvey. Miss Harvey got on the phone. The rug is sold.
And that was all the same morning of the 26th?
Yes, ma'am.
Is there any chance you could be confused about the dates?
I really don't think so. I recorded all of this shortly after that email chain that you've read through. So there wouldn't be any reason for me to wait on that.
When you say you recorded it shortly thereafter, what did you record it
I mean,
in?
I took notes on what had transpired.
Have you looked at your phone records?
No, ma'am. I don't even know how I would do that. Get them from the telephone company?
Was it a cell phone?
Yes, ma'am.
You can look at all the calls made to and from your cell phone. You could even look at it in your call history on your phone itself on your device. Now this was many months ago, so I'm not expecting that. I'm just saying that's one way. And yes, you can always get your phone records from the phone company. All right, but you said did you take handwritten notes?
Yes, which I later converted into word processing.
All right. Did you then take any additional actions after you had your phone call with Ashley, with Miss Harvey ended?
Yes, I called the police in Lakeway and asked them to show up at the shop to make sort of a mediation between me and the owners. The conversation was not very pleasant with Ashley, and so I felt that it would be better to retrieve the other rug with some police presence.
And so then you traveled to the Lakeway store?
I did.
And did you go to the Lakeway store on August 26th?
I think I did. Yes. Of course. Yeah.
And did you get back the second rug?
Yes, I did.
When you were at the Lakeway store, who did you interact with? Was it Donna? Was it Ashley? Was it someone else?
The policeman wouldn't let me go in the shop. So he was the intermediary between me and Ashley and whoever else was in the store. I don't know.
Was the rug brought out to you?
Yes, it was.
Is that date correct, Mr. Bay?
As far as I can remember.
Miss Heinrich, Miss Weller, I understand. I'm asking defense counsel. Do you know
Okay.
the date of the police? Because that's an easy one to get.
The date of the police, it was September 1st. And I sent over several exhibits that showed the sale was on the 1st. And
Miss
the documents
Weller,
were requested. Yeah.
is there a chance you're confused about the dates?
Yeah, I guess so, if he says so.
Well, I mean, the police report would be the most accurate depiction of the date, right? So you said that's been provided as an exhibit.
Does he have the police report?
Miss Weller, please
Yes,
allow
ma'am.
me to ask questions in the court. Okay? Because this is technically, you're the plaintiff. Your lawyer should have this stuff. But Mr. Bice, do you have the police information?
I do not have the police information, Your Honor.
Why do you believe it was September 1st? What information gives you that?
Well, September 1st was the date the sale of the rug occurred. It was also, it also occurred over Labor Day weekend, Your Honor.
How do we
it was
know
a busy
that?
time at the court. Well, it would be my client's testimony. I suppose, I mean, you're not going to confuse the busiest weekend of the year.
People confuse all kinds of stuff, y'all. I don't believe anyone's here being dishonest intentionally. I'm just saying, like, without y'all having to worry about your memory, look at the security footage. Call the Lakeway police and say, what day did y'all show up and involve yourself in this one? Counsel for both sides. That's an easy fact to establish in the pattern when we've got a question about what actually happened. Okay, so we don't know. She says it's the 26th. Y'all are saying it's the 1st. You both believe you're right, but no one's got anything whatsoever historically to prove this. Does anyone have any offer of proof besides opinion or testimony?
Your Honor, I did send over the receipt, so we know what day the rug was sold. So if she's saying she was told the rug was sold on one day, the receipt shows the rug was sold on the 1st. There's a Visa. I mean, I could send everything over again. I had to label it because she took screenshots of it. But
Let me open it up here. It's coming through. My clerk's been attaching it.
And one of the images I sent over as well, Your Honor, was the back side of the contract, which you'll see has the inventory of the 2 rugs that were dropped off. So those have been written down, and then the prices were what they were priced at is included next to that.
Okay. All right, look, we're going to go through those exhibits too. Ms. Weller, let me finish asking you a few questions about kind of the pattern of what happened. So your testimony is that you found out the rug had been sold on the 26th. You went that day after you called the police, you went to the Lakeway store and you retrieved your second rug.
That's correct.
All right,
Ma'am, could I add a comment?
go ahead.
Yeah, they listed on, they finally gave me the tag for the second rug, not the first rug, but the second rug. And it indicates that they said the rug was an Aubusson rug. It is a Bessarabia. I'm not an expert on rugs, but I have established that with the evaluator. So I questioned somewhat their research on the rugs and possibly the value of them. But yes, I did go to this Lakeway store, retrieve the other rug.
Okay, and
Because it was being sold, they were stipulating that it should be sold for $400. It was a 10 by 11, approximately 6 by 10 foot size rug in very good condition, selling for $400.
Ms.
An
Weller,
antique rug. Thank you.
Ms. Weller, when you got
Yes.
the second rug back, did it have a price tag affixed to it?
They gave me a tag, a copy of a tag, and I have it here in front of me.
I think I saw that in an earlier exhibit. And is that just one tag or is it both tags?
It's one tag. With the date of August 24th on it.
Mr. Heinrich, was that provided? And if so, what exhibit was that?
No, it was not provided, Your Honor, but since we have recovered the rug, that rug is not the subject matter of this lawsuit.
But that's the tag for the other rug.
It's the tag for the other rug, yes, Your
And the
Honor.
date on that tag says,
8/24.
Mr. Heinrich, is that correct? 8/24? For an Aubusson rug, red multicolor? $400. Okay, thank you, Ms. Weller. So defendant, one of the things they sent over the break matches up with that, right? Here is a screenshot from defense counsel about the 2 items. And so they were entered August 24th. They were processed the same day. There is an Aubusson rug, red multicolor, price $400, and an 11 by 15 antique Mahal rug, cream, orange, rust, and blue for $700. It was sold for $700. Net due $350. The $400 Aubusson rug was returned. Both of those are marked September 1st.
I see that. I have the same item.
All right. So you got your second rug back. Did you then reach out to the defendant's office, either Lakeway or Westlake, about disputing the value of the rug at $700?
I did.
And did you do that via phone, via email?
That was the day that Ashley and I had the conversation I referenced earlier.
No, after that, you've gotten your rug back now. You went
Yeah.
up there with the police, you got your second rug back, you're back at your house. Do you then contact the store and say, I want more than my $350 because you sold my rug for too cheap? Or did you just hire Mr. Heinrich and begin the action?
I told her I thought it should have been sold for a greater price on the day that I had the conversation with her,
Yeah,
not after that.
So
Not
after that, there was no other conversation between the parties until this lawsuit began.
Oh, she banned me from going
That's
to,
fine. I'm just.
Your
Mr.
Honor, there
Heinrich,
was a
did you want to
demand
point out,
letter
Was there
sent.
any? So she hired you and you sent a demand letter over to the defendant.
Yes,
Got
and it's number 7.
All right. So pretty short together. All right. Mr. Bass, any questions for Ms. Weller?
Yeah, I would like to cross her, Your Honor.
Go ahead.
Ms. Weller, have you co-signed with furniture brokers before?
I'm sorry, I don't hear very well. Can you speak up?
Yes, of course. Can you hear me better now?
Yes.
Have you co-signed with furniture brokers before?
Yes, I have.
Approximately how many times?
How many pieces of furniture or how many times?
How many pieces of furniture?
20.
Okay, so it was fair to say that you were a returning customer on August 24th?
Yes.
And when you dropped the rugs off on August 24th, did you have a written appraisal?
Did I have a what?
A written appraisal.
No.
Did you have any documentation for the rug on August 24th?
The homeowner's policy.
Well, you didn't have that with you.
No, I didn't have it with me, but the rug had been appraised at $9,000 by homeowners for a homeowner's policy a few, maybe years before that. I'm not sure.
But that wasn't provided by you.
That's correct.
And the exhibit 4, the appraisal that we were looking at earlier, that was you got that after the obviously after August 24th.
Yes,
Did you pay Mosin for the appraisal?
absolutely not.
Okay. Why didn't you obtain an appraisal before the rugs were dropped off?
You want to know the real story? My husband has stage 4 or 5 Alzheimer's disease. We live in a 2-story house. He was upstairs in a bedroom. My kids insisted that he move downstairs to the guest bedroom. In the guest bedroom are several tables that I'm holding for eventual placement in a facility for him. And the rugs were in there too. There was no room for his shorts, pants, shirts, socks, underwear, anything. So I had to clean the closet out. That's why I took the 2 rugs from the guest bedroom to, and it needed to be done fairly quickly because he needed to move downstairs sooner rather than later.
Well, Ms. Weller, as someone with 3 family members with Alzheimer's, I'm sorry about that. I know how hard it is.
Thank you for that.
Do you yourself possess any training or expertise with appraising rugs?
Of course not. I just have been shopping them and looking at them for many, many years. My house is full of antiques, including rugs that Mr. Mosin has looked at and repaired for me.
And referring to the contract, I don't think we need to pull up the contract. You've seen it enough today. Would you agree that by signing the contract, you accepted its terms?
Yes, of course.
And you would acknowledge that the email provided on the contract is not a valid email?
Yes, I do. Did you just ask me, though, how many times I dealt with furniture brokers before? They had my email address in their filing system for sure.
Okay.
I mean, the
Wouldn't you
series of
agree that-
emails with Donna shows that they had my email address, my correct email address. Oh, this was a hot day. I was flustered. I'm delivering 2 rugs. I'm driving to Lakeway with my husband to help me unload. Randy was really not available to unload. He was taking care of the shop. I mean, it was a very difficult exchange, and there were maybe 10 or 12 other rugs rolled up and stacked up on their end in the back of that shop. I really don't know how the rug was laid out and sold so quickly.
Do you know how Furniture Brokers sends out its inventory list and initial pricing to consigners?
Yes, I've received either on the spot from Ashley an estimate of the list price, item list price, when I took quite a bit of furniture to her a few years ago. And I've also received emails to the hnweller00@gmail.com. So she has my email address in her system.
Those previous emails, were those sent by a customer service representative or were they sent by an automated system?
How would I know that? I don't know.
So would you agree that it's presumption by you that Furniture Brokers communicates with its customers in the same manner it sends out with its initial pricing and inventory?
Don't understand your question.
Aren't you presuming that just because they sent you an email, that's the same way that email was sent to you with the initial pricing and inventory?
Huh?
Could you say that again? I believe she's having a little trouble.
Rephrase it, please. I can't understand or hear.
Of course. So you dealt with an individual via email on August 24th and 25th, correct?
Yes.
You exchanged emails?
Yes.
Aren't you presuming that that's the same method, the same email system that's used to send you the initial pricing and inventory?
I wouldn't know, really.
That's a reasonable presumption. And not helpful.
The email address
read
on
the
the chain of emails with Donna is fblakeway@sbcglobal.net. Does that, okay.
Did you read the contract before signing it, Ms. Weller?
Yes.
And anywhere on the contract, does it say that Furniture Brokers considers appraisals in its evaluation of pricing?
Where's the contract? Didn't it say that
I'll share my
research
screen
would be
and I'll look
done
at-
to establish the price?
It says it will be based on brand, quality, condition, current market value trends, web-based research, past store sales history, and owner input. So there's no controlling feature here. All of these things are taken into account when creating the price. Brand, quality, condition, current market value trend, web-based research, past store sales history, and owner input.
Can you point anywhere in the contract, Ms. Weller, where it says that your knowledge or consent is required prior to selling the rug?
No.
And it's your testimony that you followed up with Furniture Brokers on the 26th on about the rug, is that correct?
I followed up the morning after I received a voicemail from Donna. I tried to call I tried to call the afternoon of the receipt of the voicemail, and the store was closed by then. I called first thing the next morning.
Is it possible the date could have been September 1st if the receipt said the rug was sold on September 1st?
Is it possible that September 1st was added to the item list appraisal later on and was not accurate?
I'm the one asking the questions, Ms. Weller. I'm sorry. I'm just asking you, is it possible that you got the dates wrong?
I don't think so, but the police report would indicate that.
Right. And you don't think the sales receipt would have any bearing on the date that the rug was actually sold?
I think that any date could be filled in the bill of receipt. The pre-approval agreement has not been offered, has it?
What pre-approval agreement?
I'm sorry, the one that they might have asked the recipient, the purchaser of the rug, to sign when she took the rug out of the shop. Maybe I'm using the wrong language. The approval notes that said that she was taking it on approval.
I think y'all called that the try and buy.
Yeah,
That's it.
there we go. Thank you.
Do you have any pets, Miss Weller?
Sorry?
Do you have any pets, Miss Weller?
Oh my goodness. Yes, I do.
How many pets do you have?
One.
And how many pets have you had over the duration of owning this rug?
A few. I don't really number. I mean, if you could give me a specific date, I'd be happy to answer your question. 30
Well, I'm
years.
just curious.
I've owned the rug for 30 years, sir.
Right. So is it fair to say that the rug has gotten a fair amount of wear or use over the years?
No, that's not accurate. The rug was in the dining room of my home as reflected by the picture. The dining room might have been used once every 5 years. So it was not trampled on. It was not worn. It was in very good shape when I gave it to them.
And other than your testimony, did you have any expert or anyone with expertise in rugs examine the rug in the 10 years prior to dropping the rug off?
No.
Why didn't you ask about the initial pricing and the inventory in the 25th email?
I didn't. Just a minute. I assumed that since Donna didn't know that the rugs were even there and that it would be quite a while before the rug would show up on the floor and it was to be stacked in the back of the shop with about 10 or 12 other rugs, that it would take some time for them to research and establish the true value of the rug. Now we know that on the 24th, according to the tag that I showed you earlier, the price was established on August 24th.
But you would agree that it would be.
And I didn't receive that documentation until days later.
Ms. Weller, so you would agree that it is furniture brokers that determines the value of the rug through research. You just said that, right?
I would hope they do the research. There's some indication that they don't. That they just completely decide what the rug would sell for, not what it's worth, and then let it go.
What is that opinion based on, Ms. Weller?
Or their record. The idea was, as the judge puts it, a trial something or other. I wanted to see if they would actually value the rug in accordance with its true worth. And what they did was to sell it quickly without sending me the item list price by email or anything else. It was already sold.
But would you agree that the contract says the items are priced to sell quickly within 30 days?
Where does it say that?
In the contract.
Could you show me where?
Mm-hmm. Initial prices are set with a desire to sell them within 1 month.
Okay. Is that the question you asked?
Yes, I was just wondering if you were aware of that in the contract.
Yeah, I signed the contract.
Yeah.
The contract also says that they'll let me know the selling price, and they did not. I never received an email. I never received any documentation of the,
Ms. Weller,
If
Ms. Weller, Ms. Weller,
thank you.
can you point to a spot in this contract where it says that you have the right to disprove or to say, I don't like that price?
Does it say that anywhere? No, it
I
doesn't.
can't find that, Mr. Heinrich, and that's the crux of the case here. That's definitely one of the elements that begs the question. This contract has some deficiencies in it, but as I pointed out over the break, when I looked back and I read it closely, the only area that I see in this contract that allows the seller who consigned it of their own free will and read this before they drop their items off, and she's done this for 20 previous items, the only thing it says is that if it's not sold within 30 days and they want to discount it, the owner can then pick it up. But owners agree, and it's in bold, owners agree to have their items available for a minimum of 30 days before requesting to retrieve them back. And it doesn't say we don't like the price.
You're right, Your Honor. Thank you for pointing that out.
So
But I
why?
think, Your Honor, it has to be implicit that you can't, it wouldn't be appropriate for someone to be able to drop off an item, leave with no idea as to what it's being priced at, and then it can be sold for whatever price furniture broker wants to put on it without any prior knowledge or an opportunity to object to the listing price.
What I'm getting at then is your position is that they have to have put it for a reasonable price.
That's correct, Your Honor.
And Mr. Vise, I think that makes some sense, right? If there's vagueness in a contract, it goes against the person who wrote it. Furniture, so the defendant wrote this contract and gave it to the consigner, right? What he's saying makes some sense, right? If I bring you my antique Ming vases and you put them up for $50 just so y'all can get them out of the store in 30 days, that's not really the benefit. That's not good faith dealing. So my question would then turn to, how did y'all come to the value, or how did the defendant come to value the rug for $700? What information will you offer from your client about how they determined brand, quality, condition, current trends, web research, past store sales, and owner input to determine that the value of the rug was $700?
So
How did that price get created?
So I have Defendant's Exhibit 1, Your Honor, which goes into it. But I will also say that it's also in my client's best interest to sell the items for the most amount of money they're worth. It's not, my client doesn't have an incentive to take an item and then just throw it out the door, because we have a profit too.
Totally agree. And obviously this was not a bad transaction between the parties. The two parties had worked together almost 24 times before for 20 previous items. So there was an understanding between the parties about how this worked. What broke down here? Now, Mr. Vise, I'm not stopping your ability to keep asking Ms. Weller questions. I'm just saying that for me, going back and forth with what we're getting to here, because I get it. The ultimate question is, if you had sold it in 24 hours, but you'd sold it for $4,000, she'd be ecstatic. She's upset that y'all sold it for $700. So the question then turns to, was that a reasonable price to sell it for? Because I don't say that y'all had a duty, that not getting her the inventory changes the situation. I don't say that she had the right to object. But the question they're bringing up, which I'm interested in, is why was it sold for that? She says that it's worth thousands of dollars, and the defendant said it was worth $700, or that was the price they came to. Now you can still ask Ms. Weller questions. Mr. Heinrich can still redirect, but if you want to help get where we're going, how did we come up? How was that value created?
So in part, Your Honor, if you look at Exhibit 1, there's 91 pages of rugs that have been sold at that store. At the Lakeway
past
store
sales.
Correct.
I'll share my screen. So that's one of those factors that y'all said that are taken into account. Right here it is, 91 pages. I'm not going to bother with all 91, but this is one thing that was used.
If you look at the majority of prices in here, though, Your Honor, you'll see it's in the hundreds. Like I said, this is a huge document, so we go page by page, but we're not talking about, I think, very clearly depicts what rugs are typically going for in a store.
I don't know about that. I went to Louis Shank's going out of business sale, and their discount price was $13,000 for rug.
Well,
Right, like,
right.
listen,
I'm
I'm
just
just
saying
saying what I think is
Right.
reasonable when I go to Home Trends or when I go to Walmart or when I go to Costco, and what you get at a like, what kind of rug is this? But one of the things y'all have is
Right.
that your past store sales show that y'all aren't selling rugs for thousands of dollars. That in 91 pages, just briefly looking through here, here's one. The most I got is a 9 foot by 12 foot Turkish area rug for $2,500. And here's one for $2,000, an 11 foot square pack Oshuk handmade rug. And then you've got other rugs in the hundreds of dollars. A red Turkish rug, 6 feet by 9, went for $800. Can you imagine? I understand this is a big session, but can you point? It's just all rugs get thrown in together, or do y'all look closer at type of rug? Like, do you go, how much did a rug of this brand, quality, and condition sell for in the past? Or is it just how much do rugs go for? Because if, what car sells for is very different than if I'm looking at, say, the Cybertruck versus a sports car versus a Toyota.
I understand, Your Honor.
But so I can see your point is that all of these are showing that $1,000 rugs aren't what they're selling. And so far, I've only seen $2,500 as the top price. None of these are getting into the 4,000 range.
Right. And ultimately, too, I would just like to point out, Your Honor, what she determines reasonable here as the contract price, and I was going to ask her about this, it's not based, it's her opinion. And she's already testified that she's not an expert, and she's already testified that the individual that she's relying upon to get that number, the 4,000 to 5,000, that they're clearly relying upon, that appraisal was done after the fact. And that appraisal was performed without him even seeing the rug. So even we disregard the breach part of breach of contract, here, how can she possibly prove her damages if no one has seen the rug and had it appraised?
Mr. Heinrich, that's a good question of fact. So how do you know that the rug was worth more than $700? If she hasn't had it appraised, homeowners policies don't count. People insure things for a whole different amount than what they're going to go for at market.
Well,
right?
the defendant's the one who made the rug unavailable.
Collection of things.
I'm sorry, Your Honor.
What evidence do y'all have to show me that the value of the rug was so much greater than the $700?
Mr. Moson's appraisal.
I don't find
it
that
was
persuasive.
based on the best evidence he had of the rug.
I don't find that persuasive enough to defeat other things. I'd find them equal this way, right? I take it as true, but I think what they're giving me just as true. And if you're trying to get me more likely than not, him not inspecting a rug that he hasn't seen for a period of years based on a photo that was itself a photo of a rug 6 years prior. My example of pictures of your kids from 10 years ago are not the same of what they are now.
Well, Your Honor, the list of rugs they've furnished you with that's 91 pages long is a list of basically every rug. There are rugs in there that are not even beginning to be comparable with what this is.
100%. I just pointed that out to them, Mr. Heinrich.
Yes, and we have no photographs. We have no real evidence of what those rugs were worth.
But you're trying to prove to me, your case is that they did not sell the rug for an appropriate value, that it should have been valued at more than $700. And I'll say, okay, I'll take it as true, but you got to get me more likely than not. So what evidence do you have besides Mr. Moson's appraisal, which I don't find to be of great evidentiary value, to show me that the rug she had at the time she dropped it off at Lakeway was worth more than $700?
I have no additional evidence than what's been offered, Your Honor.
If you go on First Dibs, you'll see this rugs like this for a lot more than what Ashley Harvey stated the rug was worth. She could have done that easily. I did it after the fact.
After the fact is not helpful at the time of the parties entering into the agreement, right?
I understand.
And I have no doubt there is sentimental value that you paid a lot of money for the rug, right? I think your testimony was that you paid $6,000 for it 30 years ago.
Yes.
And then put money into it. But I don't have any knowledge of rugs. If they appraise and die, if they go down, what I read a lot in the news is that antique items keep going down in value because apparently my generation doesn't want any of these things. I had dinner with a wonderful family friend last night who's trying to give me their china because no one of their relatives wants it. They have
Our people shop at
dining
IKEA.
rooms filled with beautiful things. Then I went, I like my Corel because I can drop it in my dishwasher and it never breaks.
That part I know to be true.
I know. And so it is frustrating. I understand that. What I would say is that I absolutely understand the frustrations experienced between the parties. I have experienced this with my own parents, actually. And myself. I think something is worth much more than they think, and people tell me it's not. And then I think there's no way someone would pay that much for it. And I am constantly amazed at what people think tennis shoes are worth. Right? If you have anyone who follows the Nike market, Air Force Ones are apparently, who knew that a pair of shoes no one wore without any autographs is in the thousands of dollars. Right? You'll hear me say a lot about what is reasonable price for things. My husband and I dispute the price of a purse. What is reasonable to spend? And he's wrong, right? I absolutely think, but do I think I need a $20,000 Hermes? Well, maybe, but probably not. I'd say I don't hear, based on the contract doesn't make it, there's no explicit provision in the contract that the value or the price to be sold at has to be agreed upon. It does say that the price they're going to determine is going to be based on a series of factors, only one of which is customer input. There's no timeline about it. And it is, pretty clear that the contract says that once you give it to them, they have 30 days. Now, I absolutely agree with Mr. Heinrich's position and that of the plaintiff that if it is something so beyond the scope of what would otherwise be reasonable, that's not okay. But I don't have any evidence before me to say that $700 is beyond the pale for what that rug was worth at the time it was offered for sale. And so with that, it would be today, plaintiff take nothing. Absolutely, both sides have the right to appeal my decision. I do understand that. For me, it is, I can't on the face of what I've got say that $700 is outside the bounds of reasonability for what that rug, why they priced it that way. I'm glad you got back the other rug though, Miss Waller. I absolutely am, Miss Waller. In that way, do that. And I wish you and your family, I empathize with the situation you're facing. As Mr. Bay said, I do understand that you're going through some difficulties, and that this is just one more thing that can frustrate all of the things you're otherwise having to deal with.
I
Okay.
appreciate your
Thank
time
you,
and
Your Honor.
attention.
Will the clerk prepare a form of order or do we need to submit one?
No, we'll take care of that in Justice Court. We appreciate that, Mr. Heinrich. I do, but we'll take care of it. We have a form. We'll send everyone that copy of the order. Okay.
Thank you. Or maybe excused?
Yes, all parties are excused. Good luck to everyone. Thank you very much for your time and your patience this morning. We do appreciate it.
Thank you, Your Honor, and thanks for your patience with us getting those additional documents. Have a nice Friday.
Everyone, good luck. And JC, thank you. Did a great job putting in the chat box, getting that contact information and adding in the exhibits as we went.
Thank you.
I appreciate always a wonderful job that you do. And then once all the parties have exited, we can
Here we
stop our